All right. Well, welcome to the VPLC crossover coffee chat. So we've scheduled this for an hour. Probably won't take an hour, but what we're going to do is go through the slides. I'm gonna pitch it to the expert in the area, person who's working on that legislation or budget amendments or whatever. And if you have any questions, go ahead and probably the easiest thing to do is put them in the chat, and we'll keep checking the chat. You don't have to wait till the end. So let's go ahead face to the next slide. And the next one, please. That's the folks that they're doing our legislative work this year. Next slide. So this is our first slide. And so I think I'm going to kick it to Emily, right?
Yes, yeah, I'll take over. Emily Hardy, I do our elder law and health benefits work, along with Victoria, who's on the chat, and Cassie, who's on leave right now. So just to jump into it, I guess our biggest push this session, which hopefully people have seen in the news because we've been working on it a lot, is trying to remove Virginia's trigger language around Medicaid expansion. Currently in Virginia, if the federal government decreases our FMAP by even 1%, Medicaid expansion is supposed to terminate immediately with everyone disenrolled through DMAS without the legislative process involved. So essentially, we are just trying to put in place some kind of slowdown to say the legislative process has to reconvene. They have to figure out a way to fund it if we can, or at least have an orderly process on how we're doing this. So that stop did get into the Senate budget, but I think we're still waiting on language on what exactly the final language was. The original proposal was to do an oversight committee with a recommendation and then probably a reconvene session. I think, the language may have shifted a little bit, but what we're really just looking for is a slowdown on automatic disenrollment of 630,000 people from health coverage. So big priority. We're very happy to see it in the Senate budget. We did not see it in the House, so there's still work on that side, which I think you'll see at the end that we have an action alert and a request to contact the House. We have been pushing on.
It might be worth repeating that number of people that are depending on that coverage.
Yeah, 630,000 Virginians, which is roughly 1/3 of our entire Medicaid program. Some of those people could be eligible for alternative coverage, but realistically, if we have an automatic disenroll process, it's unlikely that they will be adequately assessed and moved over to categories. And also, because of Medicaid expansion, there are certain things that stopped happening in Virginia, like evaluating people's disabilities to determine if they were eligible for ABD. And so those people will be disenrolled even if prior to Medicaid expansion, they would have been eligible for ABD because they would not have gotten that assessment. So there are, both roughly 630,000 people at risk, and some of those people should keep health coverage, but it's not clear that they would given sort of the changes that happened after expansion. And then and that's going to be a pretty minimal amount of the 630,000 that should be ABD, but we don't think those people will be correctly assessed. Some of our other budget amendment items failed. They were partly in there this session because it's the second year of a biennium to keep the conversation on them going. And then our hope is to push on them next year. One is to switch Virginia sort of from a 209B state, which is that SSI recipients are not automatically enrolled, into a 1634 state, where if you get an SSI status, you get coverage in Medicaid. So hopefully that will be more amenable under the next administration, but we just wanted to keep the conversation alive. In the meantime, we also are working on emergency Medicaid coverage to cover cancer for individuals who would be eligible for Medicaid, but for their immigration status. That is obviously a hot topic. I don't want to say hot topic, but there is obviously contentious federal actions happening right now that put that at risk as something to push on. So we'll be evaluating how to proceed around emergency Medicaid and other services for individuals as we move forward in this administration. We did work on a Medigap bill to help eliminate discrimination in Medicare supplemental coverage here in Virginia. So currently it is legal for health insurance companies to discriminate against you based on your pre-existing conditions when you try to switch from one Medicare supplement to another. And we had to eliminate the ability to switch to a lower plan because the health insurance industry convinced legislators that that meant that people would be talked into worse coverage and then regret it, which really people were talked into coverage they didn't need and regretted it. But it still allows you to switch from the same plan with one insurance company to another, or the same plan to one that is less expensive. So it's a step in the right direction. People cannot be underwritten if these pass, if they are trying to change insurance companies. So the Senate one passed out of Commerce and Labor last night after a lot of excitement, where it died 2 weeks ago, came back to life last week, died last night, and then came back to life as the last bill to pass before crossover. So it did pass Commerce and Labor 8-7 after much too much excitement for what it does. So it's a small step in the right direction, but it was a very stressful bill. We are also waiting on language to see if our Medicaid eligibility appeals made it into the Senate budget. It did not make it into the House. The goal for this was pretty small. We just want to expand the timeline so that people have 90 days to appeal rather than 30. We know that with mail delays, and Virginia being one of the 10 worst in the state for mailing Medicaid information to recipients, that they often don't have a chance to appeal or don't understand that they can do the reconsideration and other processes. So this was just to clarify that they have this longer timeline, given that they often get their notices beyond the timeline. Next page.
Sorry, my computer is very slow.
Oh, no worries.
I'm hitting the button. All right, lost track.
Similar to the other page, the Cover All Kids Amendment, we wanted to keep in motion this year, but we understood it was unlikely to pass due to being the second year of the budget. And it did fail. Maybe a bill again next year rather than budget, but that's something we're evaluating. This is the first year we've brought the next item. We did get some traction on it. It's a Medicaid continuous coverage provision from ages 0 to 6. So children in that age group would not be subject to renewals or terminations during these periods. What we see is a lot of kids have churn. So they get kicked off the program, they get back on it, they get kicked off, they get back on, which disrupts continuous coverage and continuous care for those kids. So that's something we're trying to solve. It did not get into the budget this year, but it is the first year we're pushing on this item, and it did get a fair amount of traction and coverage. So we are hoping that in a different year of the budget, we can move this forward. One of the items that did get a lot of support was presumptive eligibility for pregnant individuals, which allows other organizations to evaluate and find someone eligible for Medicaid for short periods of time while their full application is pending to get full coverage. The House bill passed and crossed over. The Senate bill failed in appropriations, but that was because the senator decided that there were too many amendments to work on at that level, and instead switched to working on budget language. So it is included in the budget on both sides, and we're waiting to see the Senate language to see exactly how the Senate decided to proceed with it. But our understanding is it's included in both, and it will be moving forward. A really great small bill that came out was Delegate Shin's special enrollment period for pregnant individuals, which lets people who become pregnant enroll in marketplace insurance at any time of the year, rather than pregnancy not being treated as a life-changing event, which is how it currently is. This bill will affect a small population of people, but it will have a large impact on those people who will now be able to access health coverage during their pregnancy. We were able to get the bill amended to eliminate barriers that are present in other states that allow this, specifically the requirement to get health care confirmation of pregnancy prior to getting coverage, because that would require you to essentially assume a healthcare cost that's not going to be covered by your insurance. So we'll be working in the off season to make sure it's as simple to access this as any other SEP, but it did pass the House. So we had in the hunger space, we were working on free school breakfast for all kids. It does say meals, but this session we're focusing on breakfast, as it's a smaller budget amount and it helps kids access and go to school if they have food there. Both of them made it to appropriations, but did not end up in the budget. So they failed this year due to cost. Again, it's the second year of the budget. So that is, a lot of our stuff is very expensive. And so that is sort of to some of it an expected outcome, even if we would prefer that we were able to move these quicker. And we also are continuing work on trying to increase the minimum amount of food assistance for seniors so that people are not getting $23. It's a modest increase to $50, which is still, as we all know, not sufficient enough money for a month of food, but it also failed this year. There were a number of smaller food access bills that did make it through. There's a House bill that creates a work group to study how to help people access all USDA benefit programs. That was carried by Delegate Price. That originally died in appropriations, but was revived and passed the House, or is on the floor, I think. Senator Rome brought a number of changes around, providing information to people. There is that the VDSS has to create SNAP eligibility information specifically for universities and provide it to them so they can provide it to their students. There is one that requires the Department of Health to provide WIC information to every food bank because we know there's a very low enrollment in WIC in Virginia. And then there is also a study to review and study how our implementation of the restaurant program in SNAP is working. And all of those have passed out of their original committees and are either on the floor or passed over. So there were some minor and good improvements in review of SNAP and other programs. They just weren't sort of the larger budget items that we're working on. And then we also only have, I guess a joyous experience because every other session for the last couple of years, there's been a sweeping amount of guardianship bills. But this year there is just one guardianship bill. It is focusing on the right to vote, which in Virginia, if you have a guardianship application or somebody seeks guardianship over you and the court is silent on your right to vote, so they don't make a decision one way or the other, you are presumed to lose the right to vote in Virginia automatically. So all this bill does is say that if the court is silent and does not evaluate your right to vote and say that you do not understand the act of voting, you keep your right to vote. It can always be addressed later if it needs to be, but this is just switching the presumption so that individuals retain the right to vote unless the court specifically says they should not. It did pass on the Senate and House side, and on the House, I know it's over on the floor already. I believe the Senate, obviously the Senate would also be on the floor. If it's passed, it should be on the floor. And we had a couple other elder law bills that didn't make it onto this related to increasing BDHS inspectors and staffing studies. And one of them creates intermediate sanctions. So it's not all or nothing. If a nursing home is a bad actor, so if CMS doesn't take action, it's not just like a slap on the wrist or closing the facility, which are essentially what VDHS options are right now. Instead, it's creating intermediate sanctions, which are pretty minimal, but do have income penalties and things like that, which will help fund VDHS's budget. I think VDH is missing at least 7 inspector slots, and they have been for a long time that have been left unfilled since the pandemic. They have a huge backlog of yearly annual reviews due to the pandemic, barring them from accessing facilities for a long period of time for non-emergency issues. And so there are a lot of items focused on trying to increase the workforce for the inspectors, as well as increasing the number of inspectors, their pay, the ability to recruit, because a VDH inspector is a really complicated position and you need to have expertise. So we're excited those are in there. They're a long time coming. The crisis for these types of inspections has been building for the last 5 years. So we're glad that those are moving forward on both sides. And that's the end. I think it's someone else now.
Good job.
So I think these are mine now. So we know that back in during the COVID crisis that Congress had a brief, fully refundable child tax credit that lifted millions of children across the US out of poverty. And unfortunately, Congress did not extend those child tax credits. So Virginia is taking a run at an expanded state child tax credit. States that have done this have seen great success. But as you can see here, we did not do this. Both the Senate and House bills failed in their appropriations bills. There were two bills to increase access to childcare for low-income families. Delegate McClure's bill is a kind of a pilot for low-income families. That one did cross over, but let's remember this is a House bill, which means that it could well die in the Senate. Delegate Glass also had a bill that would have sort of ameliorated the benefits cliff from when people start making more income, and rather than being cut off completely from childcare aid, which might make them lose the job that is giving them that increased income, it would have slowly tapered off as their income increased. That bill died. Improving access for services for non-English speaking families. Sheila, do you want to say anything about that? There was a BA in the Senate, not the House, so it means that it'll be subject to whatever negotiations they do.
Exactly. I'm Sheila. I work on domestic and sexual violence issues. So this is for language access services, money to go to DSS to distribute to state agencies. And it's $4 million in the Senate budget for FY26. So as Valerie said, we're going to have to work on the House to get some money from the House because it wasn't in the House budget. Next slide.
Hello. Okay.
So we had a budget amendment in both Senate and House. This would have provided legal support to families that are facing Child Protective Services investigations. It would work to keep children safe while reducing placement of children in foster care. In states that have done this, they have seen that around 92% of the children in these investigations do not enter foster care, and instead the families' other legal issues, which might be eviction or access to public assistance, are resolved, and the children can safely remain at home. The attorney can give advice on what should be in the safety plan for the family and lots of stuff like that. So that did not make it into the budget, but I'm going to try this again next year. I'm actually hoping that it's possible that we can completely bypass the General Assembly to access federal dollars to cover this program. And if that's the case, we don't have to worry about the General Assembly. But in any case, if we do have to have a bill or a budget amendment for it to access these federal dollars, we'll have a 2-year budget cycle rather than a 1-year budget cycle. So it's probably better anyway. There are a bunch of foster care bills, and one of the ones that we asked legislators to carry was one to inform foster youth of their rights to file complaints with the Office of the Children's Ombudsman without having to gain the consent of the agency that has custody of them. Oh, you turned the page.
I switched it. I'm trying to go back. I'm sorry, Valerie. Let me.
And that bill came from Youth in Foster Care. They, in an advocacy workshop, they had asked to create an oversight body over foster care. And so when I said, well, how is that different from the Office of the Children's Ombudsman? They said, oh, we don't know about the Office of the Children's Ombudsman. So this bill seeks to rectify that and adds youth under the age or between the ages of 12 and 21 to the definition or to the list of people who need to be notified of the Office of the Children's Ombudsman.
Now I'm back and you're probably ready for me to switch.
No, I'm still not ready for you to switch. Thank
Okay,
you. Senator Favola had a bill to expand foster youth access to housing. This is when youth are leaving foster care and leaving the financial supports that they can get once they reach age 18, between the ages of 18 and 21. And many of them become homeless at that time. So Senator Favola's bill basically requires the departments to work together to access various forms of housing aid that are available to these youth and work out plans to make it so that youth can access these funds and also issue a report. Delegate Tata has a bill to extend services to youth up to age 23. Those are not going to be the financial supports that we see in the Fostering Futures program. These are going to be services which is funded by Title IV-E money. This is going to be funded by Title IV-B money. And current federal law allows states to extend these services up to age 23. A new law that went into it, that was passed by Congress this last year, will allow states to access those funds up to age 26. I asked Delegate Tata to increase to age 26. She didn't, because the Department of Social Services has not yet received guidance from the federal government on how to implement the new act. And I suggested, and the act doesn't go into effect until federal fiscal year, which is October. I suggested that they could do a delayed enactment on extending it to 26, but she decided just to make it simple and keep it to 23. Now you can change to the next slide. Thank you.
And now it will let me. Hold on. There's a very special spot. There we go.
Okay, this is to Sheila.
So there is a bill, companion bills on the House and Senate side. And what this is about, and the significance of it, is making sure that out-of-state orders are enforced when they're violated, just like a Virginia order. The reason this is important is because for some, especially victims of domestic violence, who may have gotten a protective order from out of state and moved to Virginia, they don't want to have to register them in Virginia and potentially tip off the abuser that they've moved to Virginia from whatever state they moved to. So those orders, through full faith and credit, are supposed to be enforced as Virginia orders. And this just puts the language in the violation statute. This military protective order bill, this is, there's again companion bills from Delegate Sewell and Senator Perry. Military protective orders are very different than civilian protective orders. They are issued, they're not in a court, they're not issued by a judge, they're issued by the commanding officer. And really, it's for the military to control their asset, the military personnel. And so they can, there's no due process involved, et cetera. So from what I understand, this bill came from someone who works at the Department of Defense. And the problem was that people, the beneficiaries of these military protective orders, thought they didn't need another protective order. So as you might imagine, military protective orders only protect them on base or military land. They are not enforceable off military property. So basically, this is guidance. The language that we've come up with is guidance for the courts or anybody who's looking at a statute, especially pro se litigants, that they may use a military protective order as evidence to prove that family abuse or an act of violence, force, or threat has happened when they're asking for that preliminary protective order. And I should say that both, let me see, the foreign protective order bills have crossed over. The House version of the military protective order bill crossed over, and I expect the Senate one, which was just heard yesterday, to pass the Senate and cross over. And this last one on this slide, HB 2130, we worked with Delegate Keys-Gamarra on a bill to basically, when there's a juvenile who is a respondent in a protective order, juveniles are different than adults and should be treated differently than adults. So there's language, hopefully, if the bill passes and is signed, that says that the court or an attorney or GAL may ask for other services to be provided to that juvenile respondent. And this came from a situation where Delegate Keys-Gamarra was the guardian ad litem for a child. And this child, there was some issue between this child and another child who were both in the same school. When Delegate Keys-Gamarra came to the hearing, the parents of the other child, the hearing was for the parents of the other child, had taken out a protective order against this child. And meanwhile, this child was dealing with a lot of issues at home. They were self-cutting. This is a child that needs services. And not to mention, if the court had issued a protective order against one child on behalf of another child, how does the school manage that? They're both in class together. What about passing each other in the hallway? So this just gives courts other options, open options to provide services for juvenile respondents. Next slide. Early lease termination for victims. This is something that has been in play for some time. Through Christie and other housing advocates, we have been able to get an option for early lease termination for victims of domestic and sexual violence. This bill would add it for warrants of stalking and trafficking, as well as for emergency protective orders and preliminary protective orders. So on the one hand, often when there are emergency or preliminary protective orders issued, that's when there is escalated violence and a person may need to be able to quickly terminate their lease and move elsewhere. On the other hand, there's some concerns about these being used by abusers against victims. So, you know, we've got concerns about the bill, but we support the intentions. This next bill, intimate partner. So over the course of Virginia history, we have been trying to expand the family and household member relationship to cover more and more intimate partner type relationships, but we don't have an intimate partner definition in the code. This bill passed last year. I expect it to pass this year, but also it was vetoed last year by the governor, and I expect the same result. So we would add that definition, but it also adds prohibitions on firearms possession for intimate partner violence. And that's it for me.
So this last thing on here on this page, it's a bill from Delegate Arnold that actually would have expanded the bill that Christie worked on many years ago, creating a way for parents whose rights have been terminated to be restored later on under certain circumstances. And we supported that bill. However, it was really the OES did not like the bill, so it was reduced. So what it does do, and I think will be very helpful, except for the fact that they've made it just really restrictive. Now that it's crossed over, I might talk to some of the senators about potentially removing some of the restrictions. But basically, under current law, if your rights have been terminated, not only you, but no one on your side of the family could ever be considered a person with a legitimate interest for the purpose of having custody or visitation rights with a child. And that's really problematic for siblings. We actually tried to see if we could challenge that a little bit in court and get rights to a couple of siblings whose, or 3 siblings adopted by 2 different families to have visitation rights. But because the siblings' parents' rights had been terminated, they had no right to have visitation with each other. So we're going to have to work on that in the future. But what this bill does is, if a child is adopted and the adoptive parents die, or if they abandon the child, which there was actually a lot of hearings this year on in the Commission on Youth on how often that happens, then if the parent meets certain very restrictive parameters, that parent could be considered a person with a legitimate interest to have custody of that child if the child is currently in the custody of the Department of Social Services. So it'll be interesting to see, there's very specific circumstance that Delegate Arnold had that this bill was meant to address. And so whether very many other people will fit within the circumstances as narrowly as it's drafted, I don't know. But it's something where we could maybe expand the envelope in the future. That's it.
Okay. Good morning, everyone. My name is Janae Craddock. I'm with the housing team, which consists of Christy Merrill, our fearless leader, and also Daniel Verzai. So Starting off with a budget amendment, which is already in the budget, which is the VERT program, the Virginia eviction reduction program. It's been in the budget since 2020. This year we asked for an additional $3.5 million because right now the need for money, should I say the need for the resources outweighs the money that's in the budget for this now. And so there was a $500,000 increase in the Senate budget, in the House budget. The Senate did not allocate any funds to the VERT program. So I'll see how that works out in the conference process. The other bill that we have is basically Delegate Cousins HB 2229, which is essentially amending the tenants assertion statute. So I jumped the gun. It actually is on third read today, but we anticipate that it will pass. But this bill was presented last year, passed both the House and the Senate, but was vetoed by the governor. And in speaking to the patron who had also been in communication with the governor's office, we think there was a bit of a misunderstanding. Let me just rephrase that. Misunderstanding in the administration office about what is the intent of this bill. And so we kept the same language from last year, which essentially addressing the access to justice issue. It allows tenants to, it makes it clear that tenants can file tenants assertions against their landlord, even if they are not current on their rent. It does not take away the fact that they need to pay ongoing rent, but the fact that they haven't paid, they may be behind, doesn't end the case. Conversely, landlords still have the remedy to file an unlawful detainer. So in theory, you could have a tenants assertion and an unlawful detainer case pending at the same time. But the intent was to make sure that tenants who oftentimes are denied access due to the clerk's misinterpretation of that statute, allow them to be able to enforce their rights that's provided in the VLTA. Also, to address the administration's concerns, we add an additional language that makes it clear that the amendments to the tenants assertion statute do not apply to any other affirmative defenses in the unlawful detainer process. Let's see. So the next one is the 14-day payer quit. That did pass in both the House and the Senate, Senator Rouse and Senator Price on party lines. It passed last year as well and was vetoed by the governor. And this is something that has been presented, I don't know, Christy maybe can tell you, I guess 3 or 4 years in a row now. But essentially, it's again, I think at this point, it's a messaging bill to make it clear that the tenants of Virginia need that extra time, that extra paycheck to avoid an eviction filing. While there have been all these other protections put into place, like the extended right of redemption to help tenants remain housed, the intent of the 14-day payer quit is to prevent an eviction filing from the beginning. So to give them more time on the forefront to avoid those additional fees and to avoid the filing, because we all know that once an eviction is on this record, it becomes problematic, which will lead to something else that we addressed this year. Can we, next slide, please? Advance it to the next slide. Thank you. Yes, so speaking of evictions and the impact that eviction filings actually have on your record, whether it's whether the tenant wins, lose, the fact that you have that, as Marty would say, that scarlet E on your record has been an issue. And that's something we addressed last year with the automatic eviction expungement rule that states that any case that's dismissed would be or non-suited would be automatically expunged starting July 1 of 2024. And so to build upon that momentum and to strengthen that, Delegate Hernandez and Senator Rouse introduced legislation in the Senate and the House that would prohibit or make it unlawful for landlords to deny housing to people with their expungement, with the evictions that are eligible for expungement to be used during the tenant screening process. One of the big questions what was asked during our lobbying and with other stakeholders as well, how would we know which evictions are in fact eligible for expungement? And the language is pretty clear in the statute that if a case has been dismissed for whatever reason, if it has been non-suited for whatever reason, it in fact is eligible for expungement. So in our eyes, if the landlord sees a dismissed or a non-suited eviction, it should not be used against the tenant. Delegate Hernandez's bill, while I said it's crossed over, again, just being anticipated expected to pass, is on third read today. The next one, HB 2218, which is Delegate Tran's bill, it's also something that we put forth last year, which was vetoed by he made some amendments that gutted the bill. And so once Delegate Tran rejected and the Democrats rejected the amendment, it was subsequently vetoed. But we reintroduced it this year with some minor changes. And so essentially what it says is that landlords are required to accept any type of lawful payment, whether that's cash, check, money order. And also if someone is paid by cash or check, the way the statute reads now that a receipt is available upon request, that language was stricken from the bill and says that if a tenant pays with money or cash or money order, that the landlord shall provide a receipt, which seems kind of a no-brainer. But we actually had heard of situations where people were being denied receipts and therefore having to defend themselves in court when they don't have the proper documentation if a payment dispute actually would arise. Also in 2218, we also addressed, and I think Christy just put this in the chat, we also made amendments to add the small landlord exception, so that landlords with 4 or fewer properties are not required to accept payments via like credit card. The concern is that like your mom and pop landlords don't have the capacity or the technology to accept credit cards, and they saw that would be like an undue burden on those small landlords. Public housing protections, and I will say that let's see. Yes, get back to Marty's question. Yes, 2218, thank you for asking that question, Marty. It does prohibit a processing fee. The way it is there has to be at least a payment available that's free. So if the landlord offers credit and also, cash, if they want to charge for a credit card payment, if it's not required that the tenant pay by credit card, that would be permitted. But if the credit card payment is the only type of payment that can be made, which this law gets rid of that, then they wouldn't be allowed to charge any additional fees. So it does address those situations where tenants are oftentimes forced into one type of payment, which also carries an additional convenience fee. Okay, public housing protections. This is something that Christy worked very closely with the city of Richmond, some other stakeholders to address some problems that we've been seeing in our public housing authorities. We're most familiar with Richmond Redevelopment and Housing as well as Petersburg. So it made sense that Delegate Cousins and Delegate Aird would carry these bills. Delegate Cousins' bill is actually up on third read today. Senator Aird's version of this bill actually passed the Senate 39 unanimously. So, but keep our fingers crossed on that. But this bill does three separate things. It makes it easier for public housing tenants to appeal eviction cases. It actually is an appeal waiver for individuals, and it only applies to individuals living in public housing, so not Section 8 or any other government funded like program or subsidy, just public housing residents. If they have an eviction, if they have an unlawful detainer for non-payment of rent, they lose that case. Right now, the only way they can appeal to circuit court is if they're able to post a bond, which is the judgment itself. And we all know that if they could pay the judgment, they probably wouldn't have been in court. And so appealing in these cases involving non-payment of rent is really just, it's more of a fairy tale than anything else. And what this does is it clears that burden, that barrier, should I say, that would allow them to appeal based on the fact that they are public housing residents and their indigent status. But it doesn't, and this is key, it gets them to circuit court, but it doesn't remove the requirement that they remain, that they continue to pay rent in order to keep the appeal going. The other thing is that when public housing authorities provide their payer quits, they will be also required to provide a notice of how to apply for hardship exemptions or interim certifications. That notice that shall be attached to the payer quit must be on brightly colored paper. I believe that we landed on pink or orange, which was a hotly contested topic. The other thing, and this was drawing on some specific concerns we heard from residents in the Richmond area, is that the excessive fees that tenants were in public housing were assessed just for simple maintenance costs, even if the maintenance request was due to no fault of their own. And so the language in this bill will prohibit public housing authorities from charging extra fees or maintenance for maintenance or repairs. Now, it doesn't do away with the fact that the VRLTA does state if the tenant is responsible for the repair work that's necessary. If it's something that the tenant did that necessitated these repairs, then that would be assessed to them. And like I said, the Aird's bill passed unanimously, and we're waiting for Cousins' bill to on third read today, but we anticipate that will pass. Is there anything in the chat that I missed?
Nope.
No, I don't think you missed anything.
Okay.
We need to.
So that may have been, and I'll be, can we go to the next slide? Oh, yeah, we have one more.
Okay.
All right, so the next one, and Daniel worked closely with Delegate Maldonado on this, and it actually did pass the House and crossed over. HB 2122, it adds extra protections for our mobile home residents. It requires that the mobile home park owner provide, if there's a floodplain designation, it requires that the mobile home owner provide notice of that to the tenant. And I believe that is upon signing the lease, but also upon renewal, as we know that those designations can change, annually. And so that way is to provide at least whether or not a tenant will be able to move their mobile home. That's a different subject, but the fact that they would at least have notice of that may be able to assess whether or not there's any additional insurances or things that they may need. Also, that bill makes it clear that the fees that can be charged to them, so the fee disclosure. The next one is a budget amendment that was not included. Daniel, I'll let you, actually, Daniel, if you want to talk about that, if you want to say something else about the manufactured home ownership, that's fine, because I know that is your baby.
And I'm sorry, Janae, it got changed for what was passed from what we originally wrote.
Sure.
It was
Mhm.
amended in the nature of a substitute that requires language to be placed in every manufactured home lot lease that states from the landlord that the tenant should obtain their own homeowner's insurance and landlords do not offer it. That the information related to special flood zones and where it can be found, and that flood zone insurance is not the same as homeowners insurance. And it was mirrored after what is already in the VRLTA. It is not this, it's not a requirement that they disclose the whole park is or is not in a flood zone. And that was mostly because once I did the research from FEMA, there are parks throughout the Commonwealth where 10 lots out of 50 are in a flood zone, but the other 40 are not. And in order to avoid confusion with those who are not in flood zones, because of the way FEMA does it, this notice goes in every single one of them. And Randy agreed to amend the code to allow for 10 days, 10 business days after a lease has been signed, they must return that signed copy to the tenant, whereas currently they're given a month to do so. And I told Randy that's how leases get lost and people never get their copy. So, sorry to jump in. I just wanted to make sure there wasn't any confusion.
No, I appreciate that. As Daniel has stepped up to be, he's been our mobile home expert now for over about a year or so. And he's definitely provided some more expertise, as it is a very particularized field, as it doesn't fall under the VRLTA. But we've been working to incorporate some of those protections that tenants have to make sure that those are provided to tenants and under the Mobile Home Lot Act. So thank you, Daniel. The last one was a budget amendment that failed in both the Senate and the House budgets. This one is that this one was supposed to be a down payment, some money for people who were purchasing, first-time home buyers who were purchasing homes in community land trusts. It seemed to get a lot of traction amongst the CLTs, as well as even like patrons and other legislators that we talked to, but I guess that just didn't translate over to the appropriation committees. And so that did not receive funding in either budget. Any questions? Or comments, Christy, if you want to add anything?
We probably ought to get going. We're running
Okay.
out of time. So
Thank you.
So on the consumer rights, believe it or not, state and local governments are garnishing 100% of people's wages to repay tax debt. We don't think any other state in the United States does this except Virginia. So we have this bill, which is expected to cross over today. It reduces garnishments for tax debt to 25%, which is like other creditors, but not exactly, because we did have to compromise to get the state tax folks off of our bill by not including the minimum protection that people get on a garnishment from other creditors. But we still have the commissioner, the Treasury people from around the state opposing us. They want to take 60% of people's wages, and we're not going to agree to that. So, but we hopefully get through the House. We'll see what happens in the Senate. And by the way, the treasurers are pretty much garnishing people for the car tax. The next bill is automatically protecting the first $500 in a person's bank account from garnishments. So that currently in Virginia, somebody gets a judgment against you, they can then garnish your bank account. It's really a horrible thing to have happen to you because your bank account gets frozen before you even know. And of course, it leads to all sorts of problems. Much like if you have 100% of your wages garnished, you're just devastated. You don't have any money to pay your rent and buy food and that sort of thing. So we put forth this bill to make it an automatic process, because otherwise, I mean, you will get noticed if you have your bank account garnished, and you can go to court and claim your exemptions. But let's face it, most people are not able to do that unless they're lucky enough to get a legal aid attorney. they're probably out of luck. And so we originally wanted to protect $5,000. We've agreed to $500, and it passed easily in the House. But there's still a lot of people objecting. We'll see what happens in the Senate. But we think it's a start. Yeah, the thinking is that at least if somebody freezes your bank account, you at least have access to $500 for some emergency money. And then the next one, Amanda, do you want to say something about that?
Sure, I can real quick. This is the Medical Debt Protection Act, and we've been working with partners at Leukemia and Lymphoma Society on this. A lot of folks with cancer face a lot of overwhelming medical debt, and so this has become a big issue for them. And we've been happy to support those efforts. And this bill has, as it says, it has passed the House, and we're looking forward to the Senate. We're still in negotiations with some of the other groups that, like the creditors and some of the providers that have concerns. So we're trying to figure out what could move forward to the governor, but we're hoping to prohibit extraordinary collection action. So seizing someone's home, their bank account, garnishing their wages, that sort of thing for medical debt. So, and trying to put a lot of safeguards in so that people can make reasonable payments based on their income, and not face those really severe tactics. So that's about all.
Oh, sorry.
There is a question in the chat from Marty. Will the bill about tax garnishments limit garnishment to repay tax debt to the usual 25%? No, as I didn't express very well, but that minimum exempt amount is not going to be exempt from tax debt. That's the compromise we made with the state tax folks, which I don't like, but we felt like we had to. So utility fairness, is Dana, you there?
Yep. We had one main goal was to have our budget amendment, which is in the House budget. It's not yet in the full budget, but it is included in the House budget. And so we're glad that it's there, which would expand, help further along in the process, the expansion of the LIHEAP Energy Assistance Program to be year-round for eligibility and application acceptance, as opposed to just a couple of times a year. So that's moving through the process. That's a budget amendment by Delegate Hernandez. So he's been a great patron working with us on that. And then what's not on the slide are just a few things. I know we don't have a lot of time, but a few of the bills that are dealing on the energy side, a lot of our work has been defense, trying to make sure that low-income people are protected in a lot of the bills that do exist. There were a ton of bills on data centers. We're still participating in the mix, but a lot of them have gone away. But there is still a budget amendment item. It's Delegate Kilgore has a budget amendment item related to data centers that would extend the sales and use tax exemption for data centers. That's budget amendment 3-5.25 number 2H. So that's a problematic because it's just extending their ability to not pay anything for being here. And understandably in Southwest Virginia, they may want data centers to come, but there are a lot of data centers and we don't necessarily need to provide state support resources for that. They have lots of money. So we're working with other advocates who are concerned about that as well. And then there's a lot of bills having to do with Appalachian Power Company. If you have a chance, please go back. As Senator Hackworth had an amazing, a really interesting bill trying to get at the issue of affordability in APCO territory. That was Senate Bill 1281. It did not pass the Senate Committee on Commerce and Labor, but it was sent to the Committee on Electric Utility Rates, better known as SEWR, to be studied. And it would basically allow local governments that can shop for power to then pass their ability to shop for power to their residents and allow their residents to buy power through them at a different rate, hopefully a lower rate, competitively than from Appalachian Power, whose residents, whose consumers have seen a 70% increase in bills since we re-regged in 2007. And then on that same vein, Appalachian Power Company put forward a bill. They deny that it's their bill, but it really, I don't know anybody else who could have thought of this. But it's Senate Bill 1076 and House Bill 2621. They started out as securitization bills, which would allow them to securitize assets like Amos and Mountaineer, which are generation plants, as well as storm costs from Helene and from the ice storm that just happened in January. If that's enough to securitize, that would allow them to lower bills that way, not significantly, but it would do something to lower bills. But those bills have now become sort of Christmas tree bills, and there's lots of other things that have been added onto them. And we've been in the middle of negotiations with a lot of other groups and the patrons and the leadership of both parties. But I will say that the Southwest delegation of senators have been Senator Stanley and Senator Hackworth really lit into Appalachian Power Company for not doing more for their residents. And obviously they are required to work with us during this whole year on ways to make things more affordable and work better with their customers who are in need. But $700, $800 electric bills had been quoted over and over and over again in this session. So both those bills are moving through the process, but they are likely to be in conference. There's lots of negotiations, and we're hopeful that we can strip them down to be just what's necessary to reduce bills and not a lot of extra bloat, which is what's been added on in the House bill for right now. The House bill is Delegate Ballard. The Senate bill is Senator Peake. And then I'll just put those here. And then obviously, and Jay, I don't know if you want to talk as much about this, but creating a fair marketplace. Obviously, we have been pushing Senate Bill 1252, which is to stop out-of-state predatory lenders. It was stripped down a little bit, but it did cross over. It passed the Senate. And we are looking forward to having that debate in the House and hopefully getting it through that process. And Jay, I don't know if you want to talk about, I have one more marketplace thing, but you want to talk about mandatory junk fees.
Yeah, the junk fee bills, these bills almost passed last year, but died on the last day of the session. It's pretty straightforward. You got to tell people what something costs before they buy it, which has become a huge problem in the marketplace. So quickly moving on, because I want to leave a little bit of time for the unemployment. Next slide. And I'll be Joanna.
Good morning, I'm Joanna, and we worked in coalition with a lot of groups to strengthen the unemployment insurance program in Virginia by pursuing some deferred maintenance and moving toward best practices. And our signature goal this year is to increase our benefit amounts that haven't been changed since 2012. So looking at getting an across the board $100 a week increase in the weekly benefit amount. That bill has passed the House and the Senate or is expected to cross over through the House today and went through very smoothly on the Senate side. So we're excited to see that move forward. Another bill also in the deferred maintenance camp will allow workers who are seeking new jobs, who are receiving unemployment, to keep more of their earnings from part-time work while also not getting the dollar for dollar reduction in their UI benefits until they've earned $100 rather than $50, which is the current cap. So this is a pro-work incentive program that encourages workers to take part-time work to supplement their UI benefits, make ends meet, and also try out new work environments and potentially prove their skills to a new employer so they can get full-time work faster. That program, the fiscal impact statement actually shows it's going to save the VEC money. So we're excited about that moving forward as well. The next bill that would give every worker in Virginia 26 weeks of support for unemployment is in the Moving Toward Best Practices camp. It's a uniform benefit duration bill. 11 states already have a practice like this. It's been a policy recommendation from many corners for a long time, and we're eager to see Virginia having the conversation about it. We know that the administration opposes this bill, but the cost is affordable as far as the way that employer taxes would pay for it. So we look forward to pushing that through conversations we have on the Senate side after crossover. Finally, also on the Moving Toward Best Practices side, there was a bill that would create a dependent allowance, give families with children an additional support while a caregiver is unemployed. That bill, while it didn't make it through committee this year, did get tabled with a letter to the Commission on Unemployment Compensation to continue looking into how to design a program that would support unemployed workers in Virginia who are caregivers. And we look forward to working with the Commission to continue looking at this policy so we can come back with a strong bill for future session. So those are the highlights on unemployment insurance.
Okay, great. Thanks. Thanks everybody for joining. There's a slide about action alerts that we send out. Any questions, feel free to email me. And thanks everybody for coming.
There's the chat. A lot of bad bills. Thank you.